Tell me if it come on. All right. Okay, it's on. All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save this United States in this honorable court. This honorable court is now in session. Please come to order.
Good morning, everybody, and welcome to the District of Columbia Court of Appeals, to our virtual argument this morning in this appeal from this motions matter and this elections matter. We have one matter before us, a consolidated case, though. The numbers are number 22AA411, Valerie Graham versus DC Board of Elections, and 22CV530, Valerie Graham et al. Versus DC Board of Elections. I understand that the parties have discussed how they will share their time, and our understanding is that Mr. Klein and Mr. Bianco will split 10 minutes and 5 minutes, and Ms. Penbrook and Mr. Sandler, 8 and 7. You know, we won't hold you to that, but let me know if I have any of that wrong. And Mr. Klein, assuming that you're starting, we'll hear from you.
Thank you, Your Honor. Good morning. Yes, I will save 2 minutes for rebuttal, but otherwise that's correct. May it please the court, I'm Andrew Klein. I'm the attorney for petitioner Valerie Graham and Appellant Initiative Committee noted I-82. The most important issue in this case is what voter statistics should be used for purposes of calculating the required minimum signatures for initiative ballot access. And it's one of statutory construction. The construction requires analysis of 3 very similar terms from 3 different sources. The charter provision uses the term latest official count of registered electors issued 30 days or more prior to the submission of petition signatures. The Initiatives Procedures Act, which was recently amended, states that the minimum number of signatures shall be consistent with the latest official count of registered qualified electors. Lastly, pursuant to DC Code 1001.05A, the Board of Elections is obligated to publish monthly the total number of qualified electors registered to vote as of the last day of the previous month. 3 different terms: registered electors, registered qualified electors, registered to vote. Now, how do we reconcile them? 2 of them are defined.
Let me stop you there if I may.
Yes, sir.
There's been a lot of debate about the meaning of official, and I followed the briefing on that. The first statute you discussed uses the word issued, and it's easy to understand that if something has been published month by month in the DC Register, it has been issued. Under your interpretation of the law, what has been issued? Or does that word just drop out because it's not in the other statutes?
Well, I don't think it drops out, but I think it becomes less relevant given the progress that's been made in managing data over the course of the years since the initiative was put into the charter. Specifically, HAVA, which is federal law, provides that there will be an interactive database, and the requirements of that database, which the District of Columbia has adopted, and it's adopted a code provision, which it says is furtherance of the purposes of HAVA, is to be managed and interactive and accessible at any time. And there are regulations making voter counts available on a constant basis. The issue with the published is there's nothing official about them. It's not even clear from the record from where they came. But more importantly than that, what's required to be published is something different based upon the terms that we're talking about. Specifically, what's required to be published are registered qualified electors. Now, qualified electors means, according to 1-1001.02, people that are at least 17 or who will be 18 on or before the next election. They're a citizen, they've maintained a residence for 30 days, and they haven't been found legally incompetent to vote. And that is the term that's used in connection with publishing. Now, the term says registered electors. The term says registered electors who were qualified electors who are registered, forgive me. And what that includes is people who are inactive. And there is a process in the regulations for culling the voting rolls and recognizing people who have moved, and those people are considered inactive. By statute, those people are supposed to be in those numbers that were published, in this case, December 31st of 2021. Now, even if something different was published, that's irrelevant, because the charter provision could not have possibly meant those numbers, because those numbers include inactive voters. Now, if I may go on in terms of the definitions, the second definition is the term registered qualified elector, which is 1-1001.0220, and it says that means a registered voter who resides at the address listed on the board's records. Now, that's a smaller category of voters, and the difference is important. Now, the term that's used in the charter is not defined anywhere, which is unfortunate, but that's the way it is. It's not defined in the charter. However, the amendment to the Initiative Procedures Act, which was passed, which became law just last year, clarifies this situation. It corrects the timing issue that the court recognized in Price, and it fixes 30 days prior to the date that the petitions are submitted. Now, that's not inconsistent with the charter, which says 30 days or more. It's more limiting, but it's not inconsistent. And to return to your point, Judge
Mr.
Fisher,
Klein, I get these distinctions you're making within the definitions, but I'm still wondering, I get that HAVA requires the district to maintain this interactive database, but it still needs to, under the charter, issue something. And it seems to be the last thing that was issued was the December data that was published in the DC Register.
right, except the problem is that data, number one, is in no way official. And number two, and most importantly, if it was published in accordance with the requirements of law, then it includes inactive voters. And that would mean that we have a larger pool. I don't know what that is. But that if that's what's referenced, then by definition, by statute, that must include inactive voters. But that's not the term that's used in the amendment to the Initiative Procedures Act.
Does it not become official? Or I'm not sure what you mean by official, but just why isn't it official just by virtue of the role this data in the register has played before the board? You know?
Well, it hasn't always played that role. If we go back and it's in our papers, the obligation to publish arose after the initiative right was created. And in the early case, we submitted documentation that reflected it wasn't published. It was just a letter from the registrar stating, oh, here's the list of registered voters. So, I mean, there are two terms, I agree. One is issued and one is official. We would submit that official has to have some meaning. And the term official is indeed what is used in the statute that was enacted in light of HAVA, official. Those are the official records. They're to be managed, they're to be manipulated, reports are to be run. The official list can be generated from there. As I said,
the term official had a well-recognized meaning before HAVA was enacted. So you're saying essentially the federal law changed the local definition of official?
No, sir. I'm saying that the local law, which was passed in furtherance of the goals of HAVA, DC Code 1-1001.05A1, changed it, not the federal law. It was passed in furtherance of the federal law, and I think the federal law is guidance as to what was intended. But no, I'm not suggesting that we're bound by federal law. We're bound by District of Columbia law. And
your opponent says with some force that this is all very interesting, seeing how many angels can fit on the head of a pin, but you were late in coming to the game. You didn't articulate this until very late in the game, and the board seemed to think that you were late in making this argument as well. What say you?
What we say is we raised it promptly after we learned of it. There was no expectation that the board would not follow the law, specifically the Initiative Procedures Act amended last year, which with some specificity said that it was to be a list that was created 30 days before the filing of the petitions. So there was no way for us to know that this would be an issue. And in fact, and it's in the record, the list that we were given upon request was one that was post redistricting. And of course, this issue has not arisen before, because I suspect that this is the first initiative that straddled the redistricting. And that's why this issue has become so important. There's no question about that. But in terms of being late to the game, unless we were clairvoyant, I don't know how it is that we would expect that the board would not comply with a law that was passed just last year, regardless of what they did before, regardless of what their practice had been. We have a new law in the books. And it says very specifically that we are talking about a list that's generated 30 days before the filing of the petitions.
I'm not sure I read that in point 16.1 too. It's, the latest official count 30 days prior. And so I don't think that means it has to be exactly 30 days prior. I think it has to be 30 or more days until you count back to the last official count. Is that not correct?
We don't read it that way, but I think the more important point is it can't possibly refer to the published statistics given the statutory mandate as to what's to be included in those statistics.
So anytime a petition is filed, does the board have to count back 30 days, look at what the database for HAVA showed at that time, and then start their verification of the petition?
It would seem to us that that is consistent with both the amendment to the Initiative Procedures Act and consistent with the mandates of HAVA as adopted by the District of Columbia, which references that this is an interactive computerized voter registration list. Interactive means it can be, the point is, the whole purpose of HAVA was to move away from paper, to move away from static, to be able to have up to the minute, up to date information. And indeed, the regulations allow any party to request this up-to-date information at any time, and contemplates that this information will be quote unquote managed, which is in the statute.
But Mr. Klein, that just gets back to my point that HAVA requires the district to maintain this information, but I don't know how you circumvent the charter's command that it be issued. Now, to be sure, with the HAVA database, I think BOE could every single day issue what they thought the proper voter count was, but they've decided to do it on a rolling monthly basis. And I guess, can you point to anything that was issued after December that would be the controlling list in your view?
That information would be under the control of the Board of Elections. I know that during the course of this case, and I believe it's in the record, there were various lists that were created. I think one was January 18th. There was a statistics roll that was created. I know there was one after the 22nd, but it has to be at least 30 days before or 30 days before. So we submit that. We use January 31st as a proxy just to show, that this is meaningful. This is not a game. But the point is, I don't know where, given the requirements of publishing, I don't know where we find an official issued total count of registered voters who reside at the address. I don't know where that is. I don't think it's ever been done if that's the requirement. And it certainly isn't done with respect to a publishing, which is required to contain inactive voters, according to the statute.
Okay, Mr. Klein, if my colleagues have no further questions of you, we will hear from Mr. Bianco, and we'll give you time for a rebuttal.
Thank you, Judge Beckwith.
Thank you very much. My name is Richard Bianco. I represent Mr. Bagwell in this case, and what we have appealed is the denial of my client's rights to review the petitions during the 10-day challenge period. And specifically, what we're seeking reversal of is the trial court's decision finding it lacked jurisdiction to decide the claim. Specifically, we contend that the court erred in finding that Mr. Bagwell did or even could have filed a challenge within the meaning of DC Code 1-1001.16 or 3 DCMR 1006. Essentially, what happened was he filed an objection to the Board of Elections procedure. He did that in writing on March the 7th. And I think what is problematic here for the trial court is that the board never acted on that objection. Instead, what the board did, or not the board, the administrative personnel of the board, specifically counsel, is essentially dismissively sent an email the following day saying essentially no. We don't agree with it, or she didn't agree with. Yes, sir.
In the reply we just recently received from the board, no, actually, it was your reply. You acknowledge, as I understand it, that a day or two after you were turned away on Sunday, the board furnished you with electronic copies of the petitions. And we're trained as appellate judges to worry about the question of prejudice, among other things. It seems to me that you had the data that you were seeking when you sought access to the board's offices. And have you come up with any new challenges to the petitions that weren't adjudicated by the board?
Well, we haven't undertaken that review. I think what's important here is that
my reaction is shame on you. If you had it in your lap and the proceedings were still ongoing, and you had then petitioned the board or written to the board and said, look what we found, and the board said, we're not interested, then then that would be a big issue in my mind. But so far as I know, there's nothing in the petition that we don't know about.
Well, I think so far as we know, there's, I mean, we only know what we know at this point, and the reason why we didn't go through the time and effort to review the petitions once they were provided is that the challenge period was already closed. They weren't, in fact, the petitions were not provided until after the challenge period was closed. So that Monday, which was March the 7th, the petitions were promised to be provided during the business day, but were not actually provided until after the close of the challenge period. So I think that's what was
Same
problematic.
time you say the challenge period was closed, you're knocking on the door of Superior Court saying, reopen the challenge period. So if you thought that was an available remedy, why couldn't you ask the board to reopen the period?
That's exactly what we did. On March the 7th, we sent a letter to the board, and I think that's sort of to my point. We sent the letter to the board saying we were denied access, we were denied the ability to review the petitions, reopen the challenge period. The following day, on March the 8th, not a board action, but an email from their attorney saying, no, we're not going to do that. So in light of the fact that we raised the procedural objection on the 7th prior to the end of the challenge period, they promised to provide the petitions on the 7th prior to the end of the challenge period. They did not. The following day, on the 8th, their attorney sent us an email saying we're not going to reopen the challenge period.
So at that point, why not go to Superior Court and request a temporary restraining order? I mean, it seems like you waited from March until June to put this before the Superior Court.
That's true. However, we also tried to put it before the Board of Elections in the form of our motion to intervene, which was then not considered for another month. And after it was considered and denied on procedural grounds, largely which we agree with, but the reason why we filed it, knowing that it was sort of a square peg in a round hole, is because there's no other mechanism in the regulations, the statute, or any of the board's practices that would have allowed us to get before them. So for fear of getting bounced for failure to exhaust administrative remedies, we wanted to do everything in our power to get this issue before the board. And we feel that we did that, sort of culminating in the motion.
You didn't do everything, because you never took an appeal or a petition for review to this court from the denial of intervention. And so if we think that under Lawrence, this is a procedural challenge that goes to the board and then to us, isn't the fact that you didn't file a petition for review from the denial of intervention fatal to your claim?
I don't think it is at all. We don't disagree with the denial of the motion to intervene. What the motion to intervene was is an effort to get before the board, but I think the board correctly notes that that effort was beyond or outside of the challenge that was already before them. And as the board found, they were not procedurally permitted to broaden the scope of the existing challenge on the motion to intervene. So that's the reason why they never addressed the substance of our procedural objection in their order denying our motion to intervene. So I don't think that was the proper vehicle to get the issue before the board. But having already tried to file a formal objection on March the 7th and having that formal objection be ignored, it was really all we had at our disposal. And then after the board decided it, once it was pending for about a month and following disposition of the matter, we sought relief in Superior Court. So, and I think ironically, the court did note that we failed to exhaust administrative remedies as a reason for its dismissal of the case, despite our efforts to do just that, which is seek the administrative remedy that whatever was available to us, even if it wasn't quite a tight fit between what the statute allows for and what relief we were seeking in the petition. I'm sorry, in the objection.
So this is sort of going ahead to the merits, but in your view, the BOE has to be open 24 hours a day, 7 days a week during the challenge period?
Absolutely not. They have to be open during their posted hours, which they were
And
not.
the posted hours were only Monday through Friday, and your client came on Sunday, I understand.
That's correct. But what the statute requires is during the 10-day challenge period that the Board of Elections be open Saturday and Sunday for the purposes of review. Now, it's true that they did not state on their website specifically what their hours were on Saturday and Sunday. However, they did acknowledge that the reason why they were not open at 8:15 is because an employee was late for work. So at the same time, they don't have posted hours, but they do acknowledge that they were supposed to be open and were not. And what I think is more problematic for the board, aside from that issue, is that when we were there, again, we tried to do whatever we can do to ascertain at what time they might be open. So we talked to a security guard, we called, we left a message, and that wasn't returned until the following day when we had this discussion with them about them providing the petitions to us before close of business, which they didn't do.
But I guess the challenge period, as I understand it, closed on Monday, and you knew the posted hours of BOE on Monday were 8:15 to 4:45, but your client did not go to BOE to review the petition at that time. So I don't understand how his failure to avail himself of a 8-hour period to review the petition before the challenge period expired gives you any injury.
Well, we think it does. And we think it does because the statute requires that the board be open for a 10 consecutive day period. They were not. My client's a hospitality worker. He's directly impacted by this particular initiative. If passed, he has a work schedule. He can only attend on certain days. And he made arrangements on a Sunday morning because he happened to be available on that Sunday morning to go down to the board with counsel to undertake that review. And the second thing is, I think we reasonably relied on the following day, the board's representations that they would provide the information electronically, which they did not do. So I think, what the technical legal argument is we were deprived of the opportunity to review it on Sunday, thus making the number of review days non-consecutive as the statute requires, if we want to look at a plain language
You don't
argument.
dispute, though, that the BOE was open on Sunday. It opened at 8:42.
There's no record, Judge. We don't know when it opened. All we have is an email saying an employee was late and we opened at 8:42. Now below, we tried to ascertain via expedited discovery exactly what the situation is, but that was denied and the case dismissed. So, at this point, I think this court addressing the merits of the dispute is difficult because there's no record on the facts.
But don't we have to afford a presumption of regularity to government agencies? And so if they're supposed to be open on a Sunday and they say they were open on a Sunday at 8:42, don't you have to come up with something more to suggest that they actually were not open on a Sunday?
Well, I think the presumption of regularity is belied by the facts in this case. Regularity is being open at 8:15. They couldn't pull that off. So I don't think we can presume anything here about their operations.
Regularity is being open at 8:15 Monday through Friday and being open at some point on Saturdays and Sundays during a challenge period. And here they say that they were, and your client left before waiting to see if they would open.
Well, we didn't know when they were going to be open. We attempt to ascertain it. And I think the factual point here is that they never told us. We had left a message. They didn't call us back to say, hey, we're open now. And I think it's also important to note that as a result of COVID protections, they had a system in place by which you could call and do exactly what we did, which is leave a message and have a time set aside. But again, we're really getting into the weeds on the facts and whether or not they were open at 8:15 or 8:45. They didn't post the hours. I think the onus was on them because they did not open at the time they were supposed to open at the time they were there. And they've acknowledged as much. They said they've told us they were supposed to be open at 8:15 and they couldn't pull that off for whatever reason.
Are the materials that you were seeking to view in person, were they available online on that Sunday?
No, they were not available online. I don't know why the board doesn't just do that. It would certainly simplify the process. They're obviously available electronically because the following day they were promised to us and eventually provided, but after the challenge period had closed.
Okay, thank you, Mr. Bianco. You've used up your small amount of time, but we will give you some time for rebuttal as well. And let us hear from the board. Ms. Pembroke, it's all you.
Thank you, Judge Beckwith. May it please the court, I'm Christine Pembroke, appearing on behalf of the DC Board of Elections. Here with me is Terry Stroud, the General Counsel for the BOE. I'd like to step back for a minute and just talk about a threshold issue of standing. We have repeatedly argued in our pleadings in the Superior Court and before this court that the parties have not satisfied injury in fact for standing purposes. And at this point, they have not submitted the requisite affidavits or other evidence that are necessary to establish standing.
Ms. Pembroke, let me push back at this point. That seems to me to be your weakest argument. In this context, Ms. Graham doesn't have to shed blood or suffer broken bones in order to have suffered injury in fact. She is an elector, and she is in fact a resident of Ward 2, which is the focus of this controversy. What more would she have to demonstrate in order for you to agree that she has standing?
She has to demonstrate some sort of a concrete harm, just merely claiming that she satisfies.
For me, what kind of harm would be concrete in your view?
Well, if she were the proponent, she would have the harm of something that she expended a tremendous amount of resources on, not going on the ballot, which would also interfere with her political speech rights. But you don't have a political speech right not to sign a petition.
So, Ms. Pembroke, I don't understand how you square that with the statute. So if you were the proponent, then I think under 1-1001.16L, you would have a recourse if your initiative were not put on the ballot or were stopped at some point. But this is brought under O2, which says if you are an opponent, you're a qualified elector, you have the ability to bring a claim. And so, I wonder why the statute isn't enough to confer standing on anyone who is a qualified elector in the district.
Well, I think TransUnion says very clearly, Your Honor, that simply having a statutory right doesn't mean you've proved injury in fact. And that's what the opponents have argued here, is just merely satisfying the statute is enough. And TransUnion and Lujan, the Supreme Court cases clearly say, no, that's not enough. You have to have some sort of an injury, and they haven't demonstrated any injury. They haven't submitted the necessary.
Who, in your view, would have an injury sufficient to bring a claim under O2?
Well, if, for example, Ms. Graham had submitted an affidavit saying, I'm a restaurant worker, and I think that this initiative is going to mean that my restaurant will not be able to stay in business and I'm going to lose my job, then she would have had perhaps a concrete injury. But she hasn't come forward with any kind of allegation like that. She's just made this a vague argument that her right not to sign the petition was somehow diluted. Well, she doesn't have a right to vote in this context because she will be able to vote on the general election for or against the initiative. And there's no political speech right that's being denied to her because she's free to go out and speak against the initiative as much as she wants to. So simply saying that her right has been diluted is not sufficient to establish injury in fact. Mr. Bianco and NODA IH2 have simply alleged violations of the statute without pointing to any concrete injury to themselves that would be sufficient to establish standing. So as a matter of law, they have not satisfied that threshold requirement. And we would ask that the court reject these appeals for the reasons of standing. We think this is a simple case. They don't have standing, case denied. But to
So
turn
let's
to
presume that there is standing. How do you think these challenges should have been brought? And you might have some distinctions between Graham's challenges and that of NODA I-82 and Bagman, but are they brought before the board in the first instance, or do they belong in Superior Court in the first instance?
Well, certainly the Superior Court doesn't have mandamus jurisdiction, but I think the statutory scheme is very clear that you go to the board, you have to make a challenge within the 10-day period. There are at least 3 published cases in this jurisdiction which say, regardless of the nature of the claim, it doesn't have to be a specific signature objection. Any kind of objection to the petition has to be brought within that 10-day period. And if you satisfy that requirement, then once the board rules on your challenge, you can file an appeal to this court.
How do you square that with, I'm going to get the provision wrong, but I think it's like 3 DCMR 1001 dot something, where you have very specific criteria for identifying the signatures that you're challenging. And it seems like you really are attacking the substance of the petition and not these procedural issues.
So the board's regulations go to, if you are challenging the nature of a signature, how you need to go about doing that. Because of course, we're getting petitions with thousands and thousands of signatures. So you need to explain, if you are attacking a particular petition signature, on what basis you're doing that, and identify that specifically. The regulations don't restrict the nature of the challenges to just those grounds. The case law makes clear that any kind of procedural grounds, any defect in the petition is something that has to be brought within the challenge period. And indeed, this court just recently decided a qualification issue brought up within the challenge period that had nothing to do with signatures on the petition.
And I assume you're going to tell me Lawrence answers this question, but that doesn't come from the statute, right? The statute says defects in the petition, not sort of concerning or related to. And so does that potentially, as a textual matter, preclude these sort of procedural challenges that are not within the 4 corners of the petition itself?
I think that Lawrence and the other cases, Davies and the Board of Elections versus the Democratic Central Committee, talk about the statutory scheme and say that the scheme is that, so to that extent, it's grounded in the statute. The scheme is that the board, because these cases are on a strict time constraint, any issues regarding the petition have to be resolved or brought up within that 10-day period so that they can be timely resolved within the 30 days that the board has to resolve challenges.
Ms. Pembroke, I need your help in fleshing that out. One of your main points is there should be one path, and it should not include a path to Superior Court. It should go through the board and then to us. But your insistence on the 10-day period leads me to wonder, let's suppose the board is entertaining a timely filed challenge and they commit egregious procedural errors. How does the challenger protest to the board and then preserve those complaints for review by us?
Your Honor, if there are egregious errors going on with the board, and I don't think that happened in this case at all, but I can understand the court's concern. I think that it is fair to say under Hesse that the next step would be to perhaps seek a mandamus in the Court of Appeals, but you can't go to the Superior Court.
So I'm proud of our court, but as you know, we don't move with great speed. And generally, if you want something corrected quickly, you seek a TRO in Superior Court. So your response doesn't give me a whole lot of comfort that these things will be resolved in a timely fashion.
Well, this court has been very diligent in resolving elections matters in time for ballot access. So hopefully you would be able to continue to do that in the future.
Let's go back to the closure of the offices. Let's assume that this had happened on a Monday and that was genuinely the last day of the 10-day period, and the door was closed and there's a sign on it said closed for the day. What would a potential challenger do in order to get timely access to the board offices and to the petition?
I think in that case, Your Honor, what the challenger should do is file electronically with the board a document that's identified as a challenge saying, we are challenging the petition for the reason we did not have an opportunity to review it as required by the statute. Mr. Bianco did not do that for Mr. Bagwell. In fact, he just sent an informal letter to the director of the agency. And then when he tried to move to intervene, he acknowledged that he was not trying to become a challenger. He didn't want to be a challenger. So
let's assume he took your advice. He filed a challenge with the board, but he didn't get it finished until day 11. Would that be an untimely challenge in your view?
yes, Your Honor.
That just seems to me to be an impossible catch-22. That if you don't have a way to cure a defect in the board's procedures, then you don't have a one path under Lawrence to go through the board and come up to us.
And I think the reason, though, Your Honor, is this. In this particular case, the board reviews every single signature on its own independently. So the extent to which a third-party challenger is going to bring anything to the board's attention that will matter at the end of the day is pretty infinitesimal. We look at the 33,228 signatures and we determine whether they're in the right ward or the wrong ward, whether the address matches, whether the name matches the address. We do all of that work independently. And
Do you compare the signature on the petition with examples of the signature that are in the board records?
we do that in the random sampling. It would be because the board's records have multiple versions of a particular voter's signatures. The time to do that would be extraordinary. So that's why the regulations.
You, as I understand it, you devoted that time to Ward 6 and looked at each and every signature in Ward 6. Why did you refuse absolutely to do that with Ward 2?
Because Ward 2 had been sampled at 100 signatures, and the data management division determined that that sampling was accurate at a 95% level. And so it met the same criteria that applied to all the other wards. The problem was with Ward 6, when we did smaller samples, we could not verify to a 95% degree of accuracy one way or the other, whether the signatures were valid. And continuing to sample smaller amounts from Ward 6 would possibly result in the same inconclusive results. So the easiest way to avoid repeatedly inconclusive results at a 95% level of confidence was to look at all of the signatures in Ward 6.
When you were looking at the signatures in Ward 6 and Ward 2, it seems like you were not always using the December districting lines. And so I think that your opponents point to a few different examples in there. I guess it's their motion for summary reversal, where someone was like Hollis Clark was signed the petition when she was in Ward 2, but then you counted her as being in Ward 2 when she would have been in Ward 6 based on the December data.
Right. So by the time the signature authentication process started, and it had to wait until we determined which wards were numerically sufficient, because you only test the signatures of numerically sufficient wards. the board's role had been aligned to reflect the redistricted wards. So the samples were pulled out of the redistricted wards and tested. And then after that testing was done, we went back to the data management division and said to them, are these results still valid with respect to the December 31 redistricted roll? And the data management division looked at that. Their statisticians looked at that and concluded that yes, those signature authentications were still valid with respect to the pre-redistricting wards. So if I may, I'd like to—
let me make sure I understand that. You thought that the relevant data set to compare this to was the December 2021 districts, but then the data management division actually used the new districts?
Because the pool by then had been aligned on our records to reflect redistricting. The problem was that redistricting hit in the middle of the process. So by the time we were doing the signature authentication, our data had been aligned to reflect redistricting. So after we looked at the wards, I think there were maybe 50 or 60 signatures that moved from Ward 2 to Ward 6. It's explained in the board's April 8th order, the adjustments that were made between the wards. They went back and looked at those signatures, those signers that had moved from one ward to the other, and determined that that was not sufficient to change the results of 95% confidence in the signature authentication for Ward 2. If I may, I'd like to turn to a couple of comments made by Attorney Klein about which voters are on the official roll. He has stated repeatedly to this court that the published reports include inactive voters. That's not true. We have stated in our briefs, if I believe it was our motion for summary affirmance, there is a footnote that walks through the definitions in the statutes and explains that the terms used in the Initiative and Referendum Act, in the charter, and in the count requirement of the board's duties all align to cover the same group of eligible registered voters, qualified registered voters. And so there is no discrepancy in the counts used for one purpose or the other. We simply do not have inactive voters in the official counts that appear in the registrar. I'd also like to point out that his arguments are untimely arguments on top of untimely arguments. The issue of which count to use was untimely raised. He should have been aware, opponents should have been aware that we were using the official count published at the end of the month. That's what we had done repeatedly. Nothing in the legislation that was passed last year affected that. That legislation was passed solely for the purpose to align which official count was used as between the 30 days before when the initiative was submitted, as opposed to 30 days before the petition was submitted.
But wouldn't their expectation perhaps have been affected by the change in the wards?
I don't see why that would be the case, because what is determinative here is the charter amendments, and the charter amendments say the latest official count issued 30 days or more before the petition was filed. And as Price points out, the charter is controlling. So the fact that their attorneys didn't appreciate what the law requires really isn't the board's fault, nor should they have been misled by the fact that we provided them with the official redistricted list, because that is what they asked for. They submitted a FOIA request asking for the voter roll after January 1st, which would have been the redistricted roll. So they asked for the wrong numbers. It wasn't for us to say, oh, do you guys understand that you're asking for the wrong numbers? We simply complied with that FOIA request.
Ms. Pembroke, do you concede that if we are basing the Ward 2 challenge on the post redistricting, that the signatures are insufficient?
That would be correct, Your Honor, and that's why this issue has come up. I think that if you look at 5% of the redistricted Ward 2, they would have needed 2,890 signatures, and I think they came in below that. So I think that's correct.
How do we know that?
So if you look at, how do you know the
Those-
percentage, Your Honor?
The numbers you just recited.
So if you, in the record, the designation of record, we provided the court with the December 31 official report. And the law says you take 5%. So the number of registered voters in Ward 2 was, on that report, was 57,804. And my calculation of 5% of that is 2,890 signatures.
Perhaps I misunderstood. I thought that you said after looking at the December 31st figures, the board then realigned voters who were now in different wards and adjusted the numbers.
That was for the signature authentication. Perhaps I don't understand Your Honor's question.
No, I appreciate your point. Thank you.
Okay. The other thing that I'd like to address is, well, as I was saying, to return to my point about Mr. Klein's arguments being untimely, the issue of the voter roll was not raised until after the challenge period closed. And it's our position that there's no reason why the opponents would not have understood that we would be using the December 31st roll based on Price and the case laws that cited the rolls used in previous instances. In fact, Price makes very clear with respect to I believe it was a February count that you would use the January, you would use the December 31 roll. But also
Ms. Pembroke, is the 10-day period jurisdictional or is it a claim processing rule?
Our position would be that it's jurisdictional, Your Honor.
And on what basis, given the Supreme Court's current jurisprudence on jurisdiction versus claim processing?
Well, I don't believe that we briefed that issue, but I would simply say that the statute requires that the challenges be brought within the 10-day period, and this court's case law in multiple cases has found that you have to bring the challenge within that 10-day period in order to preserve your claim before the Court of Appeals. That's what Lawrence says, that's what Davis says, that's what the Board of Elections versus Democratic Central Committee says. But to get back to my other point, Mr. Klein's arguments with regard to qualified registered voters and the roles being different, all of that was brought up before this court. There's no mention of that whatsoever before the Board of Elections. So that argument is a new argument being brought on appeal, which under this court should not consider.
Thank you, Ms. Pembroke. We've given you quite a bit of time, and I think we'll turn now to Mr. O'Leary's counsel, the intervener's counsel, Mr. Sandler.
Yes, thank you, Judge Beckwith, and may it please the court. With respect to the minimum number of signatures required, there's only one official role maintained by the board. It's the role maintained under HAVA. The question is, when do you count it? It changes every day. When do you count it for purposes of determining the minimum number of signatures required on the initiative petition? The statute, the charter provision, which prevails, could not be clearer. As the court indicated, it's the latest official count issued 30 or more days prior to submission of the signatures. And the count issued 30 or more days prior to submission of the signatures was the one published by the board, or the December 31st count. Again, there's no ambiguity, there's no conflict here. The issue, the suggestion that well, first of all, there's no indication that those statistics are anything other than official. Where else would they be drawn from? Where's the factual indication that they were drawn from other than the official HAVA electronic database? There's nothing in this record that suggests that. Secondly, with respect to the published statistics, the wording of the charter, again, is the latest official count of registered electors, registered voters. The statute regarding publication is the total number of qualified electors registered to vote. The board only registers people they think are qualified. The fact is that the published statistics do not include inactive voters. Now, if
Well, wait a minute. Somebody could be qualified and be registered and then lose their qualifications by being inactive, couldn't they?
yes, they could, but in fact, the board statistics that are published only include active voters. If Ms. Graham believes that the publication statute has been violated, that's a different lawsuit. The record is undisputed that the published statistics only include active voters, and that's what the charter provision includes also. There's complete consistency here. There's no, this word game about registered qualified electors registered to vote versus registered voters is there's no distinction. The published statistics were active voters as of that date. With respect to just to clarify, in terms of the redistricting, because the correct statistics to determine the minimum number were the December 31st pre-redistricting statistics, the board properly, in ultimately determining the number of signatures found valid and submitted and the number of signatures in the universe subject to the random sampling, the board correctly assigned vote signatures to the ward pre-redistricting. So if somebody lived in Ward 2 as of December 31st, and that address wound up in Ward 6 after, the correct assignment would be Ward 2, not Ward 6, because you can't have a different number used to determine the minimum number of signatures and which signatures are valid. So it has to be consistent, and that's exactly what the board did, and their action was correct.
So I'm sorry, Mr. Sandler. I thought that Ms. Pembroke said that they initially had used the post-redistricting data.
Sorry.
So you get the point of my question, so I'll let you answer.
Yes, yes, they initially did, but then they correctly realigned those signatures for purposes of determining how many had validly been submitted. They used the pre-redistricting ward assignment, consistent with the assignment of addresses in the voter roll used to determine the minimum number. That only makes sense.
And Mr. Sandler, you didn't that this claim was.
I'm sorry, I couldn't hear.
You did not claim board's issue was brought outside the 10-day challenge window.
Well, that's a good point. Correct. It's sort of the court really doesn't need, in our view, to reach those issues, because the issue of the correct number of minimum number of signatures required and the random sampling were, whether brought timely or not, they were included by Mr. Klein in Ms. Graham's challenge, notwithstanding that they weren't signature by signature requirements, and the board addressed and disposed of those claims on the merits. It's sort of a moot point. I mean, we agree with the board they were untimely, but it really doesn't matter. The board disposed of the merits, and their disposition was absolutely consistent with the plain language of the relevant statutes.
So just to be clear then, you think the 10-day deadline is a claim processing rule that can be waived, which allows the board and us to consider this claim on the merits?
Yes, the board, we believe that the merits are so clear here with respect to the minimum number of signatures as well as the random sampling that it's not an issue. The board doesn't have to reach the jurisdictional versus claim process. Mr. Klein may have been late, You know, he was late, but the board addressed the issue, disposed of it. The board didn't say we're not going to consider it. They addressed it on the merits and did so consistent with relevant statutes. And then finally, just with respect to the issue raised by Mr. Bagwell, you know, he shows up on a Sunday morning, the next to last day, waits 10 minutes, does not come back later that Sunday, does not come back Monday. And on the strength of that, wants to disenfranchise 33,000 district voters who signed this petition. We think that's clearly would be just an outrageous abrogation of the right to initiative of the proposer and the proponents of the signature. But the key thing is he could have filed a challenge. The idea is, well, it's only signature by signature. Mr. Klein's challenge with respect to the number of signatures and the random sampling, those were procedural. I mean, those were not signature by signature challenges. The board entertained them and disposed of them. Mr. Bagwell at No 182, Chef Jeff could have filed a challenge on Monday, so we didn't have time. We think this goes to it either goes to the validity of the petition or it doesn't. If there's a claim that, you know, had we been able to inspect the signatures, it might have affected the validity. That is a claim, a challenge to validity that under the statute goes to the board first, and then over which this Court of Appeals has exclusive jurisdiction. It does not make sense to interpret this statute as allowing piecemeal appeals of different issues about the same petition. That's not consistent with the whole policy against piecemeal appeals. Thank you.
Thank you, Mr. Sandler. Mr. Klein, we will give you a couple minutes for rebuttal.
Yes, thank you very much. Mr. Sandler says it's clear. The charter provision uses the term registered electors. It's nowhere defined. There are two other terms that are used that are defined. I certainly would ask that the court pay close attention to those definitions, because the definition of what is to be published is to include inactive voters, and there's a process in the regulations for inactivating based upon incorrect addresses. This moving around the voters, this defeats the very purpose of a centralized database. We have a database, it's the official rolls, and in doing this process, the Board of Elections thought, well, we don't need to do that. We're going to rely on these old published numbers, which by law are supposed to include inactive voters. And then we're going to use the new data and we're going to move all these voters around. HAVA, and more importantly, the District of Columbia Code amendments in furtherance of HAVA contemplate those are the official records. That's what should be looked at. Let's keep in mind that if these petitions were filed 8 days later, we'd be looking at the January 31st statistics if you go with what the Board of Elections says is proper.
Mr. Klein, can I interrupt? I'm sorry that this may be a stupid question, but what is the gist of your dispute over inactive voters?
Inactive voters, if indeed are supposed to have been included in the publishing by the definitions and by the statute, and if that were done, and that's deemed the official statistics, then the numbers would be higher. But that's, we're told, even though it's not on the record, that that's not what was done, but that's certainly under the statute what's supposed to be done. And we would submit that, given that that's what's supposed to be done, that's not what the Charter Amendment contemplated. It contemplates what's in the Initiative Procedures Act, which is the registered qualified electors, who are people by definition in the code who continue to reside at the same address. And we think it's a very important point. And it's as clear as this is, that's very clear if you parse through the statute. Now, the notion, we heard that the chance that anyone would find anything that would be brought to the attention of the board that would matter would be infinitesimal. I would point to the sampling issue, which any AP first semester statistics student knows was done improperly. And what would be the method for challenging that? NODA I-82 did not and could not, didn't have the capacity to properly file a challenge, yet they have the statutory right to be watchers and to watch this process. We have no idea in terms of the selection of the individual pieces of data or whether that was done correctly, because NODA I-82 was deprived of that right. And we know, based upon what was done in the moving around of voters in and out of the sample universe, that what was relied on was no longer a random sample, because every data point in the universe did not have an equal chance to be selected. Those that were not in the data universe when the selection was done had no chance to be selected. They were moved in later. Resampling should have been done, and it was not.
Mr. Klein, I didn't even take the first semester of statistics, and I suspect that maybe the members of the board did not. I'm receptive to the argument that you essentially forfeited that protest because you didn't bring an expert witness before the board, or you didn't flesh it out. You may have identified it in a sentence or two, but you didn't really flesh it out. So why should we even care about the random sampling issue?
Two reasons. One is the Board of Elections quotes an expert from whom we have not heard. We don't have a letter with respect to this point. There were letters with respect to the other sampling that are in the record. There's nothing with respect to the change in the sample pool. And second is, you don't need to be a first semester statistics student to look up the definition of a random sample and see that it requires that every data point in the data universe have an equal chance of being selected. It's axiomatic. That is what a random sample is. And if the marbles were not in the bucket when the sample was done, then they have no chance of being selected. It's just really pure and simple. It's not any more complicated than that. It's like suggesting that I need a math expert to prove that 2 + 2 is 4. It's a definition. One need only look it up in any dictionary. And you can see what the definition of a random sample is, and you can analyze for yourself, well, it can't be random because all of the points in the data universe from which the sample was selected were not in the universe when the sample was selected. So they had no chance of being included. So I don't think we waived it. I don't think we need an expert on that point any more than we would need an expert to prove that 2 + 2 is 4. It seems very, very clear. And we didn't, and just to be clear, I at no point said what was published and whether it included inactive voters. I don't have any idea what they published. All I'm saying is that if you construe the statute and you construe the definitions, what was supposed to be published was let me make sure I have the term right. The qualified electors registered to vote. Qualified electors are those that meet the requirements. They're over 17, they're citizens, and on, and they're registered. But Judge Fisher, as you pointed out, people move. That doesn't mean they're no longer qualified electors registered to vote, but they shouldn't be included in the pool. And if they were supposed to be, and we take at face value that they weren't, they should have been, and we need to go back and figure out the right number, because this is not the right number.
Thank you, Mr. Klein. Mr. Bianco, we will also give you a couple minutes for rebuttal.
Thank you very much. I only have 2 points. One, this notion from BOE that we should have filed a quote unquote challenge within the 10-day period is contradicted by their own regulations. Specifically, 3 DCMR 1006.2 states that the board will only adjudicate a properly filed challenge. Then it defines what a properly filed challenge is as one that identifies the signature or circulator defects. and that there be enough of them to the measure. We could not have filed the challenge. We did not have the petitions till after the close
Ms.
of the
Pembroke
period.
says, though, that that is the guidance if you are going to challenge a signature, that you be specific. But she seems to say that the board would have considered a challenge such as the one you wanted to make here.
If they, I mean, I don't know what they would have done, but according to their own regulations, they could not adjudicate it. And also this note that we didn't, we sent an informal letter. I mean, I would describe the letter as formal, setting forth our procedural objections in light of their own regulatory requirements, saying what such a challenge must consist of. So we count it as an objection because their own regulations said that essentially we couldn't file a challenge. And
Mr. Bianco, maybe we're dealing with semantics here. You have just used both the word challenge and the term objection. I grant that the regulations define challenge, but you think the board really would have refused to listen to a procedural objection that had
yes,
been raised to them in the proper manner?
I would say yes, because we did raise it with them and they didn't consider it. We sent a letter. I agree with you that it's semantics. Why is the letter that we sent couched as an objection not worthy of board consideration? And if I wrote challenge on top, then they claim it would be worthy of board consideration. I agree with you that it's semantics.
Do we know the board ever saw your letter?
There's definitely no order. I don't know whether they saw it. They never responded. I got an email response from counsel saying, we're not going to give you this relief. So I don't have any indication whatsoever that the board saw it or ruled on it, knew about it. But the fact that it's called objection, rather than quote unquote challenge, if they really intended on considering the merits, they just would have considered the merits. And they never did. The Superior Court didn't. And what we call it, I think, is largely irrelevant. But the fact is, we raised it, and it was never considered.
There was a time when you and other counsel were standing in front of the board. Did you ever raise this when you had the attention of the board members?
Yes, I did. And they, again, did not decide it. It was in the context of my motion to intervene, which their decision on was, we can't grant you your motion to intervene, so the substance of your arguments are not considered.
And you have assured us that you're not challenging their decision on the motion to intervene.
That's correct. We didn't, because it was this sort of square peg in a round hole issue. We knew what we were raising didn't fit squarely within the existing challenge, but it was the only procedural vehicle in the regulations that would have got us before the board. We got before the board. And again, for the second time, they didn't consider the merits of our argument on the access issue. I think it's also important to note with respect to this notion of voters being disenfranchised, 30,000 of them, that's not what we're saying. What we're saying is if they have the signatures, it'll go on the ballot, just not maybe at the exact moment they want it to, but it's more important to get it right. So nobody's being disenfranchised, not at all. If they have the votes, it'll go on the ballot. And finally, the last point I want to make is there was some discussion and the court pressed Ms. Pembroke on the notion of an injury in fact. And the example that she gave is the exact situation that my client is in. He is a restaurant worker. He is impacted directly by this particular measure. And yes, he is at risk of being financially impacted by the measure and potentially his restaurant closing as a result. So he is the exact test case that BOE identifies. So they can't with a straight face argue that there is no injury in fact. There absolutely is with respect to Mr. Bagwell. Thank you very much.
Thank you, Mr. Bianco, and thanks all of you for your briefing and your arguments today under challenging circumstances. We will take these cases under advisement, and we are mindful of the importance of acting quickly here. And so we will proceed with a sense of urgency in issuing our decision in these cases promptly. Thank you, and you may all sign out.
This
Thank you.
honorable court is now adjourned.